I saw here again another issue recently in the news was I read that a 14-year-old kid who's now 17 to be sure, but in South Carolina, got sentenced to death in a case where there was a shooting of a 6-year-old kid, I think, at a schoolyard that resulted in his death. And of course, needless to say, that's a quite horrible event that should never happen. All of us get that. But the kid's 14 at the time. So one wonders, could he be tried as an adult even if there were statutory authority permitting it? And I'm not sure there is in South Carolina, but even if there were, could they try him as an adult? I mean, my goodness, that's a multi-layered question that I don't know if it's still been resolved by the U.S. Supreme Court. It's been there on a few occasions. And at the moment, I don't have one off the top of my head like I usually do on that subject. But just think about that. I mean, 14 years old, and even if the sentence get commuted, it's likely to be life in prison without. And I don't know a lot of the details of this case, to be sure, and what happened. But just, the youth of the actors involved here. Wow, it just makes you wonder. And but it makes me a bit thankful, by the way, because those of you that follow my videos and my work know that I spent 5 months back there in the South Carolina jail cell, locked up for a felony of practicing law without a license, and never got to trial. So I did a great job. Maybe this kid should have gone in there and appeared in prior persona sui juris. But this kind of thing, and yeah, technically you could argue cruel and unusual punishment under the Eighth Amendment, and that's a frequent argument, by the way, in death penalty cases. And it's never, by the way, as far as I can tell, and I've read a lot of cases over the course of almost 5 decades, never has that gone there in concert with the Ninth Amendment, which is where it should come from. Because if you're saying Eighth Amendment, that's the Bill of Rights, and the 904, the U.S. Supreme Court are going to interpret that to mean that you're making the argument as a citizen of that non-existent 14th War Amendment. But the Bill of Rights doesn't apply to the states. That's the first thing I said within 10 seconds of my South Carolina case, and I gave them the cite to it off the top of my head. It doesn't apply there. So I wouldn't make the argument unless I were to use the Ninth Amendment. But then, given the fact that, as people that follow my videos are well aware, the crown jewel of my unopposed issues is that there are no states. If there's no states, then none of those courts in anywhere, let alone South Carolina, are properly in session. And they lack authority to hold any trials, let alone impose any sentences. Even if a jury were the ones, and I think juries these days in most jurisdictions are given the option as far as the penalty is concerned in a death penalty case. But with no states, there's nothing there. And by the way, what's important about that is that in an earlier time, when the Constitution was taken seriously, here's a quote that you might want to think about, where it came out of Montana, where this guy committed a murder on a reservation in Montana, a military reservation, and got tried in Bozeman, I think, Montana, in a state court, and got convicted, and they almost had the rope around his neck, and his attorney said, "Not so fast." And it wasn't Lee Corso either. And he went to the Montana Supreme Court, and which had just then been recently admitted as a state. It wasn't all that long. And they ruled that the defense counsel was correct, and that Montana, had not, or had not reserved jurisdiction on that military fort when it came into existence, according to the agreement with the United States. Not surprisingly, a very short time after, charges were filed in the federal district court. Along comes the same attorney. Not so fast. When Montana joined the Union, they did retain civil and criminal jurisdiction, and the case should have been tried there. The federal judge, who, realizing that now they can't retry this guy because now he has double jeopardy in the state court, right? He's going to walk. Here's the exact quote. "It is unfortunate that a murderer should go unwhipped of justice, but more unfortunate yet that a court without jurisdiction should exercise it." Cases People v. Tully, 140 Federal Reporter, 899, page 905. And I wish this one was from the 904. It's one of the few cases I cite that isn't. But that's the priority here. If the court doesn't have jurisdiction, it can take no acts against our life, liberty, and property. And that's exactly the situation they were in with this kid in South Carolina who was in a territorial tribunal, which his defense counsel should have pointed out and ended the case. And that would have been tragic in its own way. I get that. I do. But for a court without jurisdiction, as I just said, you can't do that. If they have a common law court in South Carolina that would have jurisdiction, by all means. I think the death penalty would still be off the table there. But nevertheless, if you had a competent court and a competent jury that could rule on the law and the facts, you bet. But we haven't had that in, God, over 100 years, maybe longer than that. And that's the real issue we have, to take up with these people is, when are you going to start doing this? I mean, you've sworn an oath to be bound by this Constitution and the laws enacted in pursuance thereof. When is it you're going to start to do that? Could you tell me that, please? I'd love to know it. So that said, I'll have updates on this case possibly as they occur, but we'll get back to it. For now, like my videos, subscribe, tell your friends, and send me an email about information on my materials at youwinincourt@gmail.com. Thank you.